So she sounds a little sweet. Jim, you got your hand raised. You have to turn your microphone on.
I do have my hand raised. I just want to announce for everybody present a reminder that tonight we have our spring social, our happy hour at Enchiladas here in Phoenix from 5 until 8. And we are celebrating a very special event tonight. It is the 10th anniversary of ACBC. So we'll have a little extra treat for everybody that shows up. And a reminder, there's no charge to attend and you're welcome to bring a friend. But that's at Enchiladas Restaurant up on off 16th Street, just north of Glendale. And love to see you there. Absolutely love to see you there. We're gonna have a very nice time. Thank you.
Thank you, Jim. And that's open to everybody, not just ACBC members. So we invite everyone. And technically, ACBC was established in 2008. It's just we weren't an Inc. at that time. We were an LLC. So it's very confusing. All right, folks. So welcome. This is, I am Diane Drain, co-executive director of ACBC, Arizona Consumer Bankruptcy Council. And our goal here is to help consumer bankruptcy attorneys know stuff. So we're really committed to think tanks every Thursday and listserv that just goes on all the time, and a website, and these videos or these CLE programs / videos. Some of them are open to everybody, and others are just simply the members of ACBC. So what we're doing today is Lisa Thompson has graciously agreed to be our speaker. She is wonderful, and it's really an issue I'm looking forward to, because I just got off a phone call with somebody else, and I said, you know what, just wait, I'll answer that after I go watch the CLE program, and then I'll know perhaps the answer. Questions down at the bottom next to the chat button. You can enter questions, and they may or may not be answered at the time you ask them. I'll kind of watch them, and if they feed into Lisa's current topics and where she's at, and then maybe interject that. Otherwise, we will just deal with them when we get to the tail end. The materials were all uploaded to the ACBC website. When I get through talking here, I'm going to upload them here. But just so you know, you don't have to download them from the chat here. You can go over to the ACBC website to events, and then down to current events, and click on Talk Softly and Carry a Big Stick. You will get a CLE certificate at the end of the program. So I think that's all I have. Lisa, is there anything to add to it?
I don't think so.
Okay. All right. It's all yours, my dear.
So good afternoon, everyone. I am so excited to be talking on this topic that is very close to my heart. I'm actually this came about because I was talking about dissolution statutes, and people were looking at me like I was making some stuff up. And I went back and looked and made sure that they were in the Arizona revised statutes, just to be sure. And so that's in large part what we're going to be talking about today, because this is a large part of my practice. I've been a business law attorney for 27 years, and I kind of ended up in this niche along with forming and maintaining businesses. But if the economy is bad, I'm shutting them down, or hopefully trying to get them healthier. So, okay, doesn't want to, hold on one second. I can't get it to go. There we go. All right, so I named this after one of my favorite quotes, and I put in more of it than I intended to. or than you really need. Teddy Roosevelt said this in 2001 when he was vice president at the Minnesota State Fair, and he is credited, even though he says that it's a West African saying, but he is credited with this saying because no one can find anything from West Africa that indicates that it was said there. Anyway, I model my practice after this. I don't know if it's because I'm lazy and I don't have the energy to bluster or what it is exactly, but bluster doesn't work for me, and being loud and ranting and raving doesn't work with me. I turn it off. And I think in this area of practice, dealing with creditors, especially when you're dealing with creditors outside of bankruptcy, you definitely need to just, this is what it is. And that's what I try to do. And I model this practice from another great quote from a great man, and that would be Dad Thompson. And if you are any of my clients, you've heard me say, or I'm sorry, if you've ever worked with me in a case, you will know that I say this all the time. You got to start out with a plan. It can be a bad plan. It can be a plan that changes, but you got to have a plan. And at least you're moving towards something. He also said another thing, which is get comfortable with your worst case scenario. And I think that this is key for this type of work. Your client is going to view bankruptcy as the worst case scenario. I do not view it as the worst case scenario. I view it as the end game. Sometimes it is the nuclear option. It is, if you file a bankruptcy for either the business or the business owners, you're done. There's nothing else in the arsenal that we're going to talk about today that you can do. So you got to start talking to your clients about bankruptcy early on, get them to a place where they're comfortable with it, see if you can do it, because as you're going to see through this presentation, it's critical for settlement and other things that you might want to do. And not to be outdone was Mom Thompson, who said, be nice to everyone. I also have followed the ISO 9000 principles, which is say what you do what you say, and prove it. And I bring this up because early on in my career, and especially dealing when I was a creditor's attorney, I had bankruptcy attorneys say to me like, oh, we're filing bankruptcy. And then they wouldn't. And so guess what? I didn't listen to them. And I continued on with collection principles. If you work with businesses in financial distress, there is a cast of characters that you will deal with all of the time. So you really want to make sure that you're not blustering to them, because sometimes if they know that they don't need to look out the window when you say the sky is purple, it might buy you a couple days that you need in order to get whatever done that you need to get done. All right, so I'm not a CPA. You always got to check the tax ramifications of any legal action with a qualified CPA and make sure that they're qualified. I like to get on the phone with my client's CPA. I've had a couple CPAs recently who pretty much were trying to be a jack of all trades and a master of nothing. Bankruptcy attorneys do bankruptcy. We don't necessarily do personal injury. CPAs are kind of the same way. You want to find one, or at least talk to, a bunch of CPAs and find one that knows this stuff. So if your client doesn't have a CPA that knows business law really well, and, TPTs and all of that good stuff, that you have one to send them to. This presentation is based in large part on my past cases. There is actual law, there is black letter law that I'm going to talk about, but there is virtually no case law, like none. I think there's been 19 cases dealing with dissolution of corporations. There's none for LLCs. So I use transparency, reasonableness, common sense, and accountability as my guides. Like if it passes the smell test, if it seems reasonable, if I wouldn't be embarrassed telling someone what we did with money after liquidation, then that's what I go with. And we'll talk a little bit more about this. I will try to distinguish between LLCs and corporations when necessary. My go-to typically is LLCs, but make no mistake, all of this applies pretty much to all types of business entities. Limited partnerships have no notice to creditors provisions as of yet. Sole proprietors and general partnerships are completely different animals. So these things apply, but it's a really different analysis than what I'm going to talk about today. Also, the LLC Act, which was just changed in Arizona, so our new LLC Act is based on the revised Uniform LLC Act that came out from the Uniform Law Commission, so much like the UCC. So you can go there and look at drafter comments, but 21 other states, as of when I checked yesterday, have adopted something similar. So these provisions are out there in other states. So California is one of them. Nevada hasn't signed on, but Nevada never signs on to anything. But you might see this in some other states. A lot of the states back east have signed on, and Rhode Island is looking at bringing this on to their statute book. So this is the list of tools that are available if you're dealing with a company in financial distress. Usually bankruptcy is your end game. I think that you need to start looking at it at the beginning, because I think that you can use it to base your analysis on what is the best decision for your client. I have way too many slides in this presentation, so I am probably not going to get to talk about bankruptcy in this context for very long, if at all. But I did put in a lot of tips at the end and a lot more gray matter than otherwise would be needed, so that you can look and see any of the tips that I have for when you're filing for either a business owner or a business. You're filing bankruptcy for them. So I call this financial distress chess. You can't use all of the tools. You don't need to. Sometimes you start one way, you pivot another way. I just talked to a client yesterday. We're totally pivoting a different way than how we started. There's no one size fits all. It's always case by case. And you always, again, keep your eye at the end. And what your end game is, do you have to file a bankruptcy? Maybe you do, maybe you don't. But you want to make sure that if you get there and you're like, oh, great, we need to file a bankruptcy, that one, your client's on board, and two, you haven't done something really incredibly stupid to ruin your bankruptcy chances or to make it so that you have to wait longer. So get information. When your client first comes to you, financial documentation is key. You got to know what's going on. Verify with the Corporation Commission what is actually on public record, and make sure it matches what your client thinks. You want to make sure that the statutory agent address is current. I just found one the other day where the statutory agent was a CPA. Don't get me started on that. But the CPA died in 2017. So we needed to change that because my client was not in compliance. You need to make sure that the addresses ownership is accurate. You want to make sure you know where the business operates. I just had one where my client actually is an Ohio corporation, done business in Arizona forever. We need to use the Arizona statutes potentially. So we needed to domesticate the corporation from Ohio to Arizona so that we use the statutes in Arizona. So make no mistake that if you have a foreign corporation that's registered in Arizona, the laws of Arizona don't apply as far as dissolution goes. So you want to make sure that you get it here. All right. You want to know what kind of taxes are owed, if any, and by whom. That is going to drive a lot of this. You want to review business contracts, if there are any. You want to be looking for personal guarantees, because at the end of the day, you want your business owners to walk out clean. There's almost always a personal guarantee. It is very rare. My clients will swear up and down there are no personal guarantees. There's no personal guarantees. There almost always is a personal guarantee. And credit card companies will always argue that there's a personal guarantee. And in fact, the statutes, if you haven't read them recently, you should look at my citation, which is 447802. It says that, first of all, you're not going to have a contract per se that you signed for a credit card. If a card holder uses the credit card, that card holder is considered bound by the terms and conditions of that, of whatever's in existence at the time. So, you know, I assume always that credit cards, there's a personal guarantee and that we're going to have to contend with that. But you also want to find out the other ones. You can also look at your client's credit reports to see if any personal guarantees are showing up there. And I recommend have them get them from annual credit or from annual. Oh, I might have gotten that wrong. It might be annualcreditreport.com, or it's annualreport.com. I think it might be credit report and I typoed on that, but that's where you want to get it. You can go to the, anyway, email me if I mess that up. All right. So more on personal guarantees. It's a community property state. The attorneys on this call know that. So both spouses need to sign to, you know, have a valid personal guarantee of the debt of the business. If you have valid personal guarantees, dissolution is not going to resolve that. Now, I don't necessarily think that if you see a personal guarantee, you shouldn't go down the dissolution path, because a lot of times, you know, creditors won't be very aggressive. Creditors will miss that they do have a personal guarantee. Creditors might decide to write off the debt as bad debt. So you just always want to keep an eye on it. In fact, I have one where I know for a fact that there is a personal guarantee that is valid. And I just filed the dissolution for my client and I sent out my notices and all of the addresses, including for the statutory agent for that predatory lender, they're not good. All the mail came back. So I don't know that they're going to be a huge problem. If they are, we're going to be filing a bankruptcy. If not, we might not be. If there's an invalid personal guarantee, you can challenge the validity, which just happened in one of my cases. Counsel filed a motion to dismiss to eliminate the spouse in the case and lost because the court found that it should be a motion for summary judgment instead of a motion to dismiss. My clients do not have the money to fight it for an uncertain outcome because there is no guarantee as to what a state court judge would do. So we went ahead and filed bankruptcy for both the husband and the wife. All right, got to know about your small business loans, especially now with EIDL and PPPs. The Small Business Administration will absolutely not negotiate, period, in a discussion. I have a good friend who's an attorney, and he, you know, he's a good negotiator, and he called. I gave him some tips. He called and they were just like, nope, we are not going to negotiate. There's no pennies on the dollar. You can reduce your payments 10% of the amount that's due for 6 months if you have a reason. You can also extend that for another 6 months, but that's basically it. You could look at cramming down the debt if it's secured, if there's a UCC1, to reduce the amount. You also, in these cases, you've got to verify that your clients use the money appropriately. And how you think appropriately is, you really want to get financials that show from the beginning of time, because SBA is taking it seriously. They're coming after people for fraud. If you file a bankruptcy and your client didn't use the money appropriately, you may be buying them a world of hurt. So you really need to make sure that you know what's going on. It's also really unclear to me how state dissolution would affect SBA collections. I actually did one where one of the debts was an SBA debt. It wasn't EIDL or PPP, and it was before the pandemic. And I sent it to Denise Falk, who's our U.S. attorney, and she called me and she said, "What is this?" And I said, "It's notice to creditors and a dissolution. It's to the U.S. Small Business Administration." And she said, "Okay, I'll send it to them." And they never sent me any kind of claim. So that's, I don't know. There hasn't been a challenge. They haven't come back on my clients. I go ahead and notice everyone. So, keep that in mind. And these are dischargeable in bankruptcy if there aren't any fraud issues. All right. So the biggest mistakes that owners make while they're in financial distress, and I tell you this because if you are advising clients, generally you are going to go down a path of like a year, 2 years, at least a couple months. You need to make sure they're not making their situation worse. Business owners in financial distress, they are like, I don't have to pay my payroll taxes or my TPTs. And for those of you who don't know, TPTs are transactional privilege tax, which it is what we call sales tax. So I'm really talking about sales tax. They'll be like, I don't have to pay those until the 15th. I know I can make it up, so I'm just going to use that money and then I'll get it back. Business owners are personally liable for these types of debt. They need to be paying them. If you have a question, if your client's going to be paying them, we'll actually do it, make them get a separate account. If they're paying their employee $3,500 and that includes the trust fund portion, the part that they hold back for the government, make them put all of it in a payroll account, and that is sacrosanct until they make the payroll tax payment. And don't take loans with predatory lenders. They sound good. The ones out of New York that I've been seeing, in order to get that loan, you have to agree and sign a consent judgment. And they would have to come and domesticate that judgment in Arizona. I haven't spent enough time thinking about it because I haven't had that issue recently, but I don't know if that's just an act that would be appropriate after you'd filed a bankruptcy, but judgment liens are now attachable to homestead. So I think that's something to consider if you've got a client that has a consent judgment and they're going to, is that something that they can continue to do without violating the stay? I know for a fact that in construction, contractors can go ahead and record their lien on a project without violating the automatic stay provision. So like I said, I haven't really thought about these in that context, but I put the bug in your ear. All right. You want to know why your client's coming now? This didn't happen overnight. Why are they here today? And, my bankruptcy colleagues, we always want to know, why are you coming to us today? You didn't start having problems yesterday and then we're like, I'm going to call an attorney. That never happened. So you really want to talk about, why they're in this situation, and get them to calm down, because that's the other thing, is you really need to strategize on these cases. And sometimes client urgency is not reality, which I know I'm preaching to the choir on that one. All right. What is your client's goal? Some clients come to me and they're like, I'm done. I'm moving to the Bahamas. I want to go sell seashells by the seashore. They're out. Some want to maintain operations. They're like, we want to continue on. And some are just unsure and need to see what happens. But you got to start with that. What is the root of the problem? Is it a hiccup? Is it something that can be fixed? I have one client right now that had a staff member who just was terrible at sales. 2 years ago, absolutely horrible at sales. Nobody picked up on it for about 9 months. There's nothing in the pipeline. So last year was bad. And now they're trying to rebuild. Do I think they can? I think they can. So we're working on that. If it's endemic, if it's the economy, if it's the market, if Blockbuster Video is your client, you're probably not coming back. So you got to start looking at that. And sometimes you got to have a reality check with your client. One of the clients that I dealt with early on in my career, the owner of the company was the greatest guy on the planet. I don't know if you believe in Jesus or Muhammad, but he was nicer than both of them. And if someone came to him and said, hey, you know what? I stubbed my toe. I can't pay my bill for 6 months. He would be like, okay. And we filed a Chapter 11 for him, and he had $1 million accounts receivable because he just didn't collect. And he was awesome at what he did. He was a fantastic plumber, but he needed to not run that company. So sometimes if you can get new management in there, that's a good idea. And you want to talk about how important the business name is. Is it possible to kind of eliminate one business and start another one, especially if it's a service business and you're not, you're just trying to start clean. I joke that I could change the name of my company every day and my clients wouldn't know. Like if I call them, they're like, "Oh, it's Lisa, my lawyer." They don't know if I'm Thompson Law Group or the law offices of Lisa Thompson. One client thinks my name is Liz, so my law firm name isn't a big deal. All right. So again, new management. If you're going to go forward, have your client get a business plan. I gave you the resource to the Arizona Small Business Development Center, which I think is kind of some iteration of SCORE, which I haven't seen around. They do a lot of free trainings. They've got to have a business plan because they can't continue doing what they've been doing. And, that's the definition of insanity. So they have to get that in play. Otherwise, none of this is going to work. All right, get ready to educate your creditors. Read their documents. I had a case and it was against American Express. My client was ultimately going to file bankruptcy. We couldn't do it for a period of time for various reasons. And counsel, this was back before we had the statutes that I referenced a little bit earlier about credit cards. So I said, I want to see the signed credit card contract. And they said, no. And I said, well, how do you have a debt? And they said, here are our terms and conditions. And I said, okay. So one day I took the 12 pages of terms and conditions with like 5-point pica, got out my magnifying glass and a flashlight, and I read them. And you know what I found? I found that the lawsuit couldn't take place in Arizona. It needed to take place in Utah, and it was governed by Utah law, which counsel in Arizona was a little grouchy about. But I felt like I was very helpful in educating him. So there are some hidden gems in there. A lot of times you'll get counsel that they haven't read their stuff. They're a factory, they're doing institutional work, so sometimes there's stuff in there that will help you. Again, prep out a bankruptcy. If you don't do this kind of work, talk to someone who does. Figure out what it looks like, because I have had success going to creditors and saying, if I file a Chapter 13 bankruptcy for these business owners, this is what you're going to get. And you're not going to see it for, I don't know, 4 years, because you're a general unsecured creditor. How about we cut a deal and we'll pay you now? Sometimes that's worked, sometimes it hasn't, but I think it's a good strategy sometimes. And determine collectability. And if you've got a good story, use it. If I have one right now where, my client's wife passed away and they ran this business together and it was this great love story, and now she's gone and he's bereaved. Do not think that I do not say that to creditors all the time, that my client's wife died, so not suggesting that anybody kill off anyone so they have a good story, but if you've got it, use it. All right. Negotiations and debt settlement. It's got to be global or it doesn't work. You've got to be able to deal with everything, or it just doesn't work and you're going to ultimately be in the same place later. So you just want to make sure that if you go this route, that it's everything, it's everybody, and you're done. So I don't even really look at it unless I'm trying to buy time and I need to get just one creditor to go away for a period of time. My client's got 20 creditors, I don't even bother. Debt settlement companies, I haven't found one that I think was good. You definitely want to read the fine print on that if you're going to go down that road. But again, I haven't seen one, not saying that there aren't, but You don't want to create something else. Receiverships are generally used by creditors and not business owners. I pointed out because it can be used by business owners, kind of goes along to the idea of changing up your management, getting someone else to run the company. Assignment for benefit of the creditors is also available. It was really hot in the 1970s and 1980s. It's coming back. I just saw an entire presentation at the Ninth Circuit District Conference a week ago or 2 weeks ago. It is coming back. So the idea is there's a new company that's formed. All of the assets are assigned to that new company and a trustee is appointed. So business owner out. Business owner is gone. And then the trustee liquidates those assets and then distributes the money to the creditors. It's much like a dissolution that we're going to talk about in just a second. But it's a good way to sell assets to a third-party purchaser, have them sold clean. And it's governed by state law, so it varies. Like Delaware is really different than Arizona, but there's not a lot of oversight to it. So state law dissolution, this is kind of the meat of today. I love the state law dissolution statutes. I think that it's a fantastic law. I'm surprised that more people don't use it. So if there aren't any personal guarantees, it's a great way to shut down the business. But it's also a tool to find out if there are personal guarantees. I call it kind of like smoke out the creditors and see what they got, because as part of the process they got to give you the proof of their debt, which is great because my clients generally never have the contracts for me to see, and I want to see what the creditors think the contract is because I might have something different. And some creditors will absolutely ignore the bar date, which is amazing. And I'm going to tell you this now. I had a case where my client, there was no guarantee on the contract, which I could actually read because my client had it. It was $450,000. It was owed to a bank, and the bank rhymes with Chase. And I noticed the notice to creditors 12 times if I noticed it once. I even went so far as to attach the state law. Like, here's your notice of creditors. Here's the state law. I sent it to every statutory agent, resident agent, Delaware, everything in the contract, and they blew the deadline. $450,000, said nothing. 2 years later, they came back and they're like, hey, what are you going to do about this? And we were like, nothing. And they said, well, but you have to pay us. And we said, well, the business is dissolved and you blew the deadline. And they went away. That's a career case. So someone was asleep, but I made sure that I noticed that like crazy, because I thought if this happens, I didn't want someone to be like, well, you didn't notice us. All right. Here's the con to this. There's no case law. So you may still get sued. There's no stay. Lawsuits may still happen, which is why it is critical that you are talking exactly about what you can do. If you get someone coming down the pike and they're like, we're going to go after the personal guarantee, you need to know, can you file bankruptcy? I think that you really need to deal with the business and get that done before you file bankruptcy for anyone. So if there's personal guarantees or taxes owed, the owners may still owe those debts. So you may go through the dissolution process, which is great. But at the end of the day, you may still have to file for your business owner. But you also don't want to file for the business owner until you've resolved the business, because you could have a trustee stepping into your client's shoes. And the business will still receive bills, statements, threats, calls, all of that good stuff, because the FDCPA does not apply. And this is probably going to happen forever, because there's nothing you can do about it. So I always give my clients a little love note for their creditors after I finish their case. Like, we were dissolved on this date. Here's the statute, blah, blah, blah. And then just have them send it to anybody who contacts them. And maybe at some point, the creditors will go away. All right. prior to dissolution, you got to review the internal governing documents of the companies if they exist. You want to make sure that you know how much stock was authorized and how much stock was issued for corporations, because you're going to need to put that in your paperwork. It in large part is wrong on annual reports, so go back and look at the articles of incorporation to make sure it tracks. You need to get your shareholders, all of them, on board if you've got more than one. Operating agreements, make sure there's nothing in there that requires some kind of vote. If you have a multi-member LLC, even if you don't have to vote on it, you want to get all your owners on board. All right, here's the procedure. For corporations, you're going to file articles of dissolution. You have to be in good standing to do so. So if your client hasn't filed the annual report, you got to get that filed. The requirement to file annual reports is abated for 6 months once you file articles of dissolution, as though you could get the dissolution done in 6 months. So I find that a little entertaining. You may still have to file another annual report, because it's typically you cannot get the dissolution done in 6 months, and you'll see why in a minute. Within 60 days of approval of the filing, the articles of dissolution either need to be published, or a notice of creditors can also be published. But the ACC now puts everything on its database, which meets the publication requirement. And this is even for the outlying counties that are not Pima County and Maricopa County. So you don't have to publish your articles of dissolution unless you want to. LLCs, the statute says that there are certain events that trigger dissolution. You may also just have your members or your member say, we're going to dissolve. And then the LLC files a notice of winding up with the Arizona Corporation Commission. And interestingly enough, you do not have to file a notice of winding up with the Arizona Corporation Commission, but I advise it at the time where you really are actively shutting down the business, because you want public record out there and you want to show that you're following all kinds of formalities. All right. Typically businesses during the dissolution process are allowed to do like everything they otherwise would do. I've had situations where we know we're going to dissolve, but for example, one of my clients needed to get through the gym show, which is a big deal down here in Tucson. And that's a reasonable thing, because he was going to maximize what the corporation was going to make at this one last time event. And then we were going to move to shut it down in March. And we also could control the money, what we were doing with that after the gym show. And then we filed it was in fact a corporation, we filed his articles of dissolution. And we didn't want to put anything out there about it before the gym show, because we wanted to maximize his ability to sell his stuff without people saying, oh, well, it's a fire sale, we're not going to pay that much for it. So you want to really think about those things if you're trying to maximize how you can liquidate your client's assets. All right, so this is the meat of this, and this is what I love. So you send your written notice to known creditors. It states basically what's in your what is in a bankruptcy proof of claim. It's got to be, the supporting documentation for the debt, contract. So you're going to get to see if there's a personal guarantee or not. They need to provide it. They've got to give you something. The claim, and I would make creditors for credit cards, you got to give me your terms and conditions, preferably not in 5-point pica, but give them to me. I want to see what you think governs this deal. The claim's got to be in writing. It's got to be mailed. Don't email it to me. It's got to be mailed to my mailing address. You need to give them a deadline for the receipt of a claim. So it's 120 days. I always add time for mailing, and I always put in a specific deadline. So I don't want to play a game with anyone about like, oh, well, I gave you 5 days for mailing and my deadline was 124 days. I usually make it like 130 days, so there's no question. I don't want to get into the minutia of it. You know, if they're going to blow me off, you know, they're either going to put in the claim immediately or they're going to wait. And if I've given them a date, there's a date and everybody's in agreement. I don't want to have those arguments. The notice provision for LLCs does not affect mortgage, pledge, lien, or anything on the LLC's property, which makes sense. There's no equivalent provision for corporations, which is interesting. But if there's a lien on property, you're going to give the collateral back and you'll deal with the rest of it as an unsecured debt. Okay, this also does not affect any contingent claims. So like if you're dealing with a commercial lease, this notice provision is not necessarily going to resolve that issue. There are ways to resolve it. It's not going to be resolved by the 120 days or the 120 days plus mailing. All right, known claims are barred if you do not get your claim back within 120 days. Again, add mailing to that. And the other thing is, if you get a claim back, you can reject it. There is goose eggs on what the reasons for rejection are. I have a colleague who does this work in Phoenix, and years ago, I don't know if he's still doing it now, but the law hasn't changed. He says, without exception, he rejects every single claim he gets on every single dissolution, period. He has a standard letter, we reject your claim. There is nothing in the law that says what is a reason for rejection. Now, I don't think that you necessarily should do that. That doesn't pass the straight face test for me. I think for me, I would reject claims if, you know, I didn't have good documentation or, you know, for the same reasons that we would object to a proof of claim. That's why I would reject it. But if a creditor gets a rejection, they have 90 days to bring a lawsuit. And if they don't, they're done. So that's pretty tight. And that's bringing a lawsuit. That's not fighting with me about it. That's not settling with me about it. It's nothing. They have to file a lawsuit. So his position was, I rejected it. They didn't bring a lawsuit. Too bad, so sad. So anyway, I left the statutes at the bottom for you. I also included the statutes in the materials. So I printed out all of the dissolution statutes for both LLCs and corporations. All right, unknown claims. So if you publish a notice in a newspaper of general circulation once, and if you want entertainment, I gave you the list of newspapers of general circulation that the Arizona Corporation Commission, the ACC, has on its website as of this morning. It is super entertaining. In Pima County, I have always used the Ajo Copper News. I have never, ever seen the Ajo Copper News, but prior to having, or Pima County LLCs and corporations not having to publish, I publish in the Ajo Copper News regularly. I feel like my clients and my practice put some of the owners' kids through school because we publish there so often. But you publish once, and our big newspaper down here is the Arizona Daily Star. It's not on the list. And the Arizona Republic is not on the list for Maricopa County. The one that I use for Maricopa County is the Gila Bend Sun, because I'm sure you guys all get that. You're on their listserv, you get notices. Anyway, so you got to publish in a newspaper once in the county where the known place of business was last located. For corporations, it's 5 years. The claimant, anybody has 5 years, they need to bring a lawsuit to enforce the claim. If they do not, then they are barred. But here's the kicker. If assets have been distributed during the winding up period and they've been sent to all the other creditors, the only thing the claimant is going to get is what the shareholders got. And if the shareholders got nothing, then the claimant's going to get nothing. right? It happens all the time. And just because you do a dissolution doesn't mean there's money to distribute to creditors. And if there is money to distribute to creditors, it's very little. I mean, it's like less than pennies on the dollar. So this is awesome. And so corporations, it's 5 years. LLCs, it's 3 years. And so they must bring a lawsuit within 3 years. So this is how you deal with your contingent claims. Now, the statutes for the corporations, it does say that if that unknown creditor comes out of the woodwork, they're also supposed to send you a claim, which makes no sense because it says that they have to file a lawsuit within 5 years. So it's a little quirky there. It's probably just a mistake, but that's in fact what it says. And you can also cut off their ability to give you or to come after you by sending them your notice to creditors and giving them another 120 days. So LLCs doesn't have that same provision, but the provision for LLCs is it's 3 years from the date of publication. Again, you only publish once in a newspaper of general circulation. Most LLCs or now that we can have virtual LLCs that have, an address that's not in the state of Arizona, then you must publish in a newspaper in the Pima County or in the county where the statutory agent is or was located, because a lot of LLCs now have foreign addresses. And so that's how you figure out what county you need to be in. Again, same provisions. If the owner's got nothing and there's a contingent claim, the only thing that the claimants are going to be able to get if they didn't have notice is what the owners of the business got. All right, so you want to think a lot about dissolution and the timing of filing the documents. Once a dissolution is formally started, and for me, I consider a formal dissolution like I file the notice of winding up or I file the articles of dissolution. That's when I consider it formally filed. I require my clients to drop whatever money they have or that they receive in my Ulta account, because I view it as that is money that needs to go to the creditors and I want to protect it. So sometimes you really want to think about when you want to start that formal process. And sometimes you want some of your contingent claims to become, liquidated so that you can just clear everything out. And you may want to look at, paying some of the personal guarantee debt prior to starting the dissolution. But again, you want to be looking at fraudulent transfers and preferential payments and those types of things. Notice everybody. I even send a cover letter stating that my clients should not be contacted further. They're represented by counsel. And, I know that there's an issue about representing the business versus the owners. A lot of times my businesses are the owners. And so I will say that I represent also the owner. Clearly, if there was a conflict, I have an issue and I would have to get someone else to jump in. But at the onset, I'm just trying to get the stress off of my client. And that's generally what I do. I look up statutory agent in Arizona. I do my research. I try to find the resident agent, which is what it's called in like Delaware or Nevada. I try to find, as many places as possible. And, a lot of people, they just ignore this. I also go ahead and publish in a newspaper of general circulation once I start the dissolution. So the order of payment to creditors after, winding up business affairs, there are no statutes detailing distributions to creditors for corporations, like zero. There's nothing. There is one provision that allows a corporation that's dissolved to deposit money with the Arizona Department of Revenue with the Unclaimed Property Division, but that's not new. You can do that anyway. For LLCs, I gave you what exactly the statute says. So that's it. General unsecured creditors, I think, should get a pro rata share of what is collected from liquidating the business. Nothing in the statutes say this. So this is Lisa Thompson's, I don't know, my own statutes. I've said this so often that I thought that it was in the statute. And I looked this morning and I was like, wow, I've said this so often that this is a narrative in my head. It is nowhere that creditors, general unsecured creditors, get anything. It just says you're supposed to deal with the debt. So I leave that to you guys to think about it. I follow the bankruptcy code because that's reasonable to me. That's what we would do in a bankruptcy. So money that's liquidated can be used for administrative expenses. I use it for priority debt. Secured debt, I give the collateral back. If there's a deficiency, we, pay it as we do with the general unsecured non-priority debt, which I pay pro rata, which again, I made up. Business owners and shareholders get paid last. And shockingly, the statute's deal more with, how to pay business owners than it does with dealing with actual creditors. So this is how I view the pro rata share, and this is what I do. And again, this is not statutory. This is just what I do in my practice. And until this morning, I thought it was actually the law. So pro rata share, if, for example, you have $100,000 in claims received, then you figure out, so total up everything that you get. So the total debt, and it's not the total debt that the company has, it's the total debt of what you received, just like in a bankruptcy, right? Some creditors don't put in a proof of claim, you don't deal with those, right? And so then if you have a creditor that has a claim for 80,000 and you have a creditor that has a claim for 20,000, then one creditor is going to get 80% of the pot and the other creditor is going to get 20%. If you collect $1,000, right, then the creditor that gets 80% is going to get $800. Right? If the amount at the end of the liquidation is zero, then the creditor gets zero, and it happens. There's no statutory requirement to provide any type of accounting or any other financial information to the creditors at the end of the claim period. You don't even need to say anything if you don't want to. I generally send a letter and say, hi, we liquidated the business. If it suits me and they're getting a lot of money, I'll send them my spreadsheet and say, like, look, you got 80% of what was there. It is shocking to me that creditors tend to go away. And I'm probably completely harming myself for saying all of this out loud. I'm probably going to get all kinds of lawsuits now. I'm going to have creditors coming out of the woodwork saying, like, wait, what is this dissolution stuff? But I really haven't. Like, we've just gotten done and we were done. I mean, the biggest problem was getting a tax clearance certificate from the Corporation Commission. So corporations, you got to get a tax clearance certificate. This, just pack a snack. It's going to take forever. Get your clients to sign all the documents 3 times. That's generally what it takes to get Arizona Department of Revenue to get you the tax clearance certificate, which just says that your client doesn't owe the Arizona Department of Revenue any taxes at all. I've gotten one once because generally what I do is the thing that I care about for my clients is the notice of creditors. I want to get that out. I want to bar the creditors from making claims if they don't put in a claim with me. So what I have done in the past is just not file the annual report and have the company administratively dissolved. I just learned recently that once you file articles of dissolution with the Corporation Commission, that it stops their process of looking at annual reports. So it won't administratively dissolve you. You have to get the tax clearance certificate unless you withdraw your articles of dissolution, which in fact I just did in another case. But here's the thing. I had to contact the ACC. I had to talk to someone there, and he shall remain nameless. But he told me about a super secret form that was so super secret that I had to send it to him because there was no way that I could file it myself with the Corporation Commission. So I filed the notice of withdrawal of the articles of dissolution. There's nothing that says that I can't do that. And I let the company administratively dissolve because we hadn't filed annual reports for like 3 years. All right, LLCs, you file articles of termination, and this is what they say. If someone said to me right now, terminate the LLC, go, I could do it in about 2 minutes. It is that easy. You are filing under penalty of perjury, so do make sure that you have handled, applied and distributed pursuant to the chapter. And again, there's nothing that describes that. So make sure that you've got good records and you know what happened and nobody went on a world cruise with liquidation money. All right, revocation and reinstatement. Corporations can revoke their dissolution, but they also, once they've gone through the dissolution process, they can reinstate for 6 years. It looks back to when they first started their dissolution process. LLCs, they may not reinstate the LLC. So if you're going to file articles of termination, you're done. That's it. There's no do-over. There's nothing. You cannot reinstate an LLC if articles of termination have been filed. You can reinstate it if it was administratively dissolved. Administratively dissolved like never happens with an LLC because there are so few formalities. All right, always be watching the fraudulent transfers and preferences when you are looking at distribution, especially if you're going to pay someone over another. Make sure that your client files final returns, business, TPT, payroll. I even have my clients prepay for preparation of their final tax returns. So for example, we're working on a liquidation right now. We have liquidated the assets of the company. We're waiting for the 120 days to pass. We went ahead and paid as an administrative expense the CPA that's going to file the final tax returns because they're going to need to be filed for 2024. Also, make sure that your client shut down with ADOR because anybody who's filed a bankruptcy has gotten the lovely proof of claim from ADOR that you get in every single case. I enjoy the ones I get because a lot of times I have business cases and my clients quote shut down their business 5 years ago, which means it's still listed at the Corporation Commission and they didn't do any final TPT reports. So we have to go and file 5 years of TPT reports that say 0. If there's a corporation, file the IRS 9982, which is only for corporations, and it says that it's shut down. And also consider canceling the EIN because EINs exist forever. I like to just shut everything down so my client doesn't accidentally or accidentally on purpose start using it because they don't want to get another EIN. Keep detailed records, shut it down, everything. And verify that all of the records are shut down. If they're in another state, they might be registered there. Shut that down. Make sure that it's clean. Administrative dissolution is if you don't do something you're supposed to with the Corporation Commission. LLCs, it almost never happens. It might happen if a statutory agent resigned and another one was not appointed. So if you're trying to get an administrative dissolution of an LLC, you could play that game if you wanted to. I did just talk to a CPA. Again, I do not have CPA after my name, but I do have friends that are CPAs that I trust because I was wondering if I could convert a corporation to an LLC and then dissolve it without having a taxable event such that my client had a lot of tax liability. And I was told that that would be a wildly bad idea if the corporation was taxed as a C Corp. But it wasn't a crazy idea if the corporation was taxed as an S Corp. Because my thought process was, I don't like having to get the tax clearance certificate. I want my clients to have paid all their taxes to ADOR. That I want. It's just hard for ADOR and my clients to all get on the same page so I can get the certificate. But if it's an LLC that's dissolving, all I have to do is file the articles of termination and we're done clean. All right, judicial dissolution, you can go through and you can have the court deal with, shutting down the business if you want some oversight, or if the members can't agree. The LLC statutes actually have provisions in case it is impracticable for the business to continue on, or the business owners are at an impasse. This doesn't handle any of the business owner stuff that we're concerned about, mostly for personal guarantees and the like, but this is available and sometimes it is an option. Aggressive creditors. I want to talk about this and then I will give everyone the ability to leave because I know I'm at my time. If you've got aggressive creditors and you've done a dissolution, that's when you look at Chapter 7 bankruptcy, because your options are, or if you've got competing claims. So I had a situation where I wanted to use the money that we got to pay the IRS, but I had the union saying that their claim was for payroll. And for union benefits. And I thought that was a pretty decent argument. I did not want to make the decision because if I made the wrong decision, someone's coming after me. So I definitely wanted to have some kind of oversight. And my choices were file an interpleader, which sounded terrible because that was litigation in state court, or to file a Chapter 7 bankruptcy. So we filed a Chapter 7 bankruptcy. We turned over all of the money that was in my trust account. Like, I filed the Chapter 7 bankruptcy, called the trustee. I said, Merry Christmas. I've got $17,000 for you. And I sent it to the trustee and let the trustee deal with it. So, I've only filed 2 business Chapter 7 bankruptcies, and it's because one, I had a creditor that would not go away and would not believe that the company was dissolved. And then I had another one where it was competing claims. And I made sure that the IRS had a proof of claim in that case because I wanted the lion's share of the money to go to the IRS so that my clients would be done with it. All right, so the rest of this is the bankruptcy statute or the bankruptcy tips that I had mentioned that that you guys can go through. I'm just going to kind of flip through them. Sometimes bankruptcy is a good idea at the get-go. So look at this slide, the one that says tips. Those are some tips that I use. Again, shut it down. Here's my bio and contact information in case anybody wants to geek out with me about quality management, ISO 9000 principles, or dissolution. So thank you very much. I want to shout out to Dad and Mom Thompson and Teddy Roosevelt for helping me with this presentation and their sage wisdom. And if there are any questions, I'm happy to stay. And so I don't get in trouble, here's the ACB disclaimer. Does anybody have any questions?
Wow. Yes, we do have some questions. Lisa, can you hear me?
Yes, I can absolutely hear you.
Okay, good. Good. Can you, so
I'm looking at
Jim's
the
is
chat.
short, but
Oh,
yeah.
I did mess up annualcreditreport.com. Thank you for that.
Yep. So Jim has a question and then Scott has a couple.
Okay, so
Guys, why don't you unmute and ask
well,
your question?
Oh, I've got one that was directly to me from Lee Horner, and he was talking about publishing a summons. You don't need to publish a summons. What you publish for a corporation is the articles of dissolution. Well, you don't need to publish the articles of dissolution because now the ACC puts everything on a CD-ROM. And so people can buy the CD-ROM every quarter for like $1,000 and change, and that meets the publication requirements. And as far as publishing for contingent claims, You just need to publish your notice to creditors. I mean, that's what I do. There's nothing that says otherwise. I mean, I don't know why you would want to publish a summons. And maybe I misunderstood the question. So if that's the case, please post something else. If the LLC, so this is from Jim Kahn, can the creditors issue 1099? I don't see why not. Does dissolution prevent, so one, can the creditors issue a 1099-C? Does dissolution prevent the tax attributes of cancellation of debt from passing through to the members? And my answer to that is yes, they can. And no, it would not. But generally, you got to remember that if someone files a bankruptcy, they're not going to have to pay any forgiveness of debt. But again, that's going to work on your timing. I mean, that's where you get chess. Like, okay, we might get a 1099 and we might have to file a bankruptcy. So we might want to do that sooner rather than later. Also, talk to the CPA that you have working with you on this, because your client might be in a situation where they're already considered insolvent, and so they're not going to have any tax liability for a 1099 and you don't care.
Thank you.
You're welcome, my friend. Let's see. Oh, Scott Hyder, nice. Something else for the quiver. He's talking about UCC 3-311, talks about accorded satisfaction by giving a check for the amount your client believes should be, payment in full. Hold on one second. I lost Scott. Okay. If you have a bona fide dispute on the amount of the debt, if you include a letter explaining the bona fide dispute regarding the amount of the claim, and you say encloses a check for payment in full, you're going to be able to get rid of that. I have used that, but I actually didn't know that there was a statute for that. I just thought that, cash in hand, there's a lot of times, like, wait, I have a check already. I can go have $5,000 right now. I think that's a great strategy, but it goes back to my comment on settlement and negotiations. Your client's got to have some money to make that claim. And it could definitely deal with some clients. And I think you'd also want to be looking at personal guarantees. So you guys see how all of this kind of interplays, right? So like if it's, there's only one debt, okay, cool. You can kind of go down the list, but then you got to look at, okay, well, maybe if there's a 1099, how's that going to affect the business owners? Do I need to file bankruptcy sooner? What do I need to do? So you constantly have to be revisiting this and pivoting. There is no time sending a letter for rejecting a claim. Oh, you don't see something in the statute. That is true, because there's very little in the statute, except the good stuff that I told you about. There is no deadline for sending a rejection. I would do it immediately, because my clients, they know when that 120 days plus 5 or plus 10, whatever I did, happens, and they want to be done. So if I'm going to reject something, which typically I don't do unless they send me crap, but if I've done it, I'm going to send it sooner rather than later, because my client wants to know if they're going to get anything or not. Is there any requirement to file articles of dissolution or some notice of dissolution? There is no requirement, because of what I said with the ACC now putting everything on a CD-ROM and allowing people to purchase it. You only want to file a notice of creditors if you want to deal with contingent claims that haven't been liquidated yet. And for corporations, that's 5 years, and for LLCs, it's 3 years. But again, the business owners are pretty protected, because these claims, once they become liquidated, they're only going to be able to get the amount that was distributed, not to other creditors, but that was distributed to the owners, which is typically nothing. I will say this, I go ahead and send my notice to creditors to everyone, even if it's a landlord, because my argument would be, if I was ever challenged, is you could have sent me a proof of claim. You could have sent me something that said, we're owed this amount in back rent, and we may be owed more in back rent because we need to still mitigate, so they had the ability to get in on the pot. So I would go ahead and do that. Again, that's the world according to Lisa. That's not in the law. But I always look at this, I think at some point someone's going to be challenged. And I want to be able to say, well, this is what I did. I didn't just wait for publication. I gave them an opportunity. There's nothing that says they can't give me a contingent claim. It's not like I rejected it,
Well, Lisa,
and I would even probably try to pay them.
can I just ask you a quick question? So
Yeah.
you're saying in a nutshell that I could literally just do a written unanimous consent of all the stockholders or members and say, we're dissolving. And that is I mean, you could even do that retroactively in a way. I think that's happened many times. And then that can trigger you at least having a good faith basis that you as a company or an LLC or a corporation are dissolving. You don't even need to inform the corporation commission about anything yet. And you can start these letters to start that 120-day time period, correct?
That's an interesting point. I think that, yes, you are correct. You could do that. I generally don't. And here's why. I am typically trying to get the most bang for my client's buck as far as selling things. And the second I put it out there and I tell the creditors, word gets out. And so then we might be in a situation where we're doing a fire sale versus someone just thinks that, because I can spin the narrative as not we're dissolving. I can spin the narrative a little bit more before I have told creditors and before I have put something with the corporation commission. But yeah, that would be a strategy if you wanted to do that.
Well, I guess my point is if you don't let the corporation commission know yet that you're dissolving, that doesn't preclude you from dissolving, at least under your LLC operating agreement or under your statutes, and start this process. And then I like your idea that you don't have to send a reason for your rejection, but like I have a client that does have money. And so we're trying to figure out, even though everyone would get a pro rata share, like you said, we sort of want to try to get this thing wrapped up so we don't have to worry about it anymore. And so using the rejection letter along with a check, by the way, this is why we're rejecting your claim, because you said don't put a reason, which I agree with, unless you want to get them to cash your check so that accord and satisfaction argument comes into play. And so you do sort of both so that if they cash the check, we're done. And you're also in the same breath saying, and by the way, if you disagree, you've got 90 days to sue us, because I think the statute says they have to sue you within 90 days of getting.
Within 90 days or they're barred.
So you do it all at once. And if they did that and they signed the check, maybe we're done. I don't know. I mean, hopefully, but I mean,
you know what? Like I said, I haven't rejected a claim. I have sent checks for I think like silly small amounts of money. Like I'm sure that trustees have as well. And it's shocking. They just go away.
Yeah.
But
I didn't know
again,
about that statute. I did not know about that statute until I started doing some research. And that statute is very specific in that it's got to be a bona fide dispute. And you've got to sort of.
But that's the UCC. That is not, so right. Like these statutes, there's nothing. But again, I always look at it, there is going to be a time where there's going to be an aggressive creditor. And I'm going to have to say, well, you know what? I followed the bankruptcy code as to what would happen with creditors. We did not have preferential payments. Because, I mean, let's make no mistake, this is kind of a private right of bankruptcy cause of action, right? No oversight, you know, and I want to be able to, with a straight face, say, this is what we did, and be like, okay, what is your problem with that? Oh, wait, you didn't put in a claim? Well, did you get notice of it? Yeah, you did, because not only did I send it to you by regular mail, I sent it to you certified, and I sent it to you certified return receipt. Explain to me the problem. You know, like, and like I said, on the ones where I've got a super, super big claim, I will make sure that I've even attached the statute. You know, and if you don't pay attention, what am I supposed to do? And so I haven't really rejected too much, but I could, you know, it might be something that I get all of my claims in, and then I decide, well, you know what? I really want to reject this one because I don't think they're going to sue us in 90 days. I could do that, but I would be a little bit concerned that someone would be like, why did you reject our claim? I'd rather just pay them some money. And I don't really like doing it where we don't have any money. Like, I kind of like my clients to at least get something or to throw money in the pot, because I prefer to send a check out so it's really clear, like, we did this and this is what you get. But again, you don't have to necessarily do an accounting. So something else just came up on the chat. Okay, so does anybody else have any questions?
Feel free to unmute yourself if you'd like.
Yeah, and I'm gonna shut down the PowerPoint if that's okay.
I'm sure you saw, but there was a few thank yous and this was wonderful programs within the chat.
Thank
Thank
you.
Yeah, we appreciate you putting this on for us. And sorry I was tardy. I trust that you got a wonderful introduction, or maybe you did it yourself.
I think that's the worst part of
And for
actually.
everybody,
Me too.
I did put a note in there, this is being recorded, so if you want to watch it again, I know my brain got fried, so I'm going to go back and watch it again. So thank you, Lisa. Fabulous, fabulous. I'm sitting here going, how could that one person know all this stuff?
Well, but here's the thing, isn't that statute crazy? Like, when you read it, and literally
Sounds like
this morning I went back and I was like, I want to put this site, because I decided to put in, because I found a cool, you know, pie chart with percentages. I'm like, I'm going to do a slide, la la la, right? And I was like, I'm going to put in the statute that says pay pro rata. It's not there. And I've said it so often, I was convinced that it wasn't something that I made up. Now, the good thing is I made it up and I think it's reasonable, so that's cool. You know, and it's what you would do in bankruptcy anyway. So that's how I follow it. But there's so little. And like the last case was, there were 19 cases on corporations, and like the last one was in 1986. And it was about something that was completely different. Nobody's challenged the notice stuff. It's not there. So
Amazing.
Jim, have you done any of these?
All right.
I have not, but I will.
Well, if you want any of my forms, let me know.
Thank you. Appreciate it.
Because again, the statute doesn't give you any forms. They're modeled after proof of claims. So, all right, everyone.
Thank you, Lisa.
So much for letting me go on and on about this.
Great job.
Well, and just so you know, Lisa, we had Maria Mathis and Diane Kearns and Craig Morris here, along with a whole bunch of other folks. So quite a mixed bag.
Well, the good thing
So
is,
thank you very, very much.
I didn't talk about bankruptcy stuff, so I couldn't put my foot in it. I didn't get there. I say something wrong or get heckled. All right.
No heckling. Thank you, Lisa. Appreciate
I'll see
you.
you guys on
Bye, guys.
Monday.
Hope to see some of you tonight.
All right.
See
I will
you
not
tonight.
see you tonight.
Yeah. See you soon.
Oh, that's
All right.
right. Thank you. We'll toast to you. How's
We
that?
will.
Thank you. Thank you.
See everybody
Bye,
else at
Lisa.
5.
Bye, everybody.